Hello, hello, hello. It's Attorney Matt Griffin coming to you from Chicago. As usual, it's a holiday weekend. We're short on court. I was going to stream a little bit of the only stream I saw out there, which is Judge Stevens. Let's do it, shall we?
Morning, Your Honor.
Hello.
Like the new deal.
Yeah. Uh, yes,
Okay, because
I have a John Abrams. That you?
Yes.
22-40065 is now called. The state of Texas versus John Michael Abrams, who is present with his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here?
Yes, sir.
Do we proceed in summary?
Yes, sir.
In summary, this indictment alleges that, are we just going on paragraph
Yes.
1?
Yes, sir. I was just confirming that, Judge. If you would, I think you need
This
to.
is the third time
Yes,
you've been
sir.
charged with this?
Yes, sir. Yes.
So what's our plan?
Well,
We
we
got
we have an agreement for 10 years, Judge.
Yeah, but
He only received on those
let me ask you
prior.
this,
Yes,
what
sir.
is he looking at if the whole indictment was pleaded to?
It would be a second degree because,
You know,
hang on, Judge. It's a second degree based upon count 2. With count 3, you can make an argument that could make him look at habitual,
what,
but the case
why
law.
wouldn't there be certainty about it? I mean, what's the argument about? I mean, if the way it's pleaded, it's a habitual felon. 25 to life.
Yes, sir.
Well, I know the people who put me in here, they don't really appreciate sex offenders who don't properly register.
I
I mean,
agree with you.
They don't stand for it.
I agree with your honor. And my agreement that's been offered to Mr. Dusler is 10 years in light of the fact that he only received a 2-year and a 3-year sentence previously. So it's incrementally more. It's not to the degree that your honor is suggesting, but that may be, I feel like 25 is
Ooh.
going a little more than what is
I
entitled.
haven't seen this.
The
Appropriate for this
legislature didn't think that. But he's
I
looking
don't
at
disagree.
life imprisonment, actually.
Judge does
It's a
not like
minimum of
this.
25.
Yes, sir.
Where was this original conviction? Out of Harris County?
Yes.
Sexual assault of a child. Um,
He sure is, Mindy.
Anybody want to explain what the consistent problem is?
He's like,
I
this
don't have a
sucks.
consistent problem with that.
I'm not doing it.
Yeah, and understand that we're serious. You may not, but you're one of the few on the planet who don't seem to appreciate sex offenders have strict rules they must follow because they failed on the rules. You'd like you. But not only have you committed an underlying serious crime involving sexual assault of a child, but this is fourth
Ooh.
time at least you have been charged with a felony offense regarding sex offenders. I don't begrudge the defense. You know, y'all doing the best you can, but
But the prosecutor.
can anybody explain to me, help me out,
I'm going to grill you.
why any mercy should be shown under these circumstances?
If I may speak,
Involved, keeping in mind a child was injured for the rest of their life.
I don't know the underlying offense originally
Well, it
because
says what it says.
it was way back in 2002.
Well, it's in the body of
Yes,
the charge.
it was in 2002 is when the offense originally happened.
Yeah, I'm looking in the,
What I,
no, the probable cause affidavit is in Harris County involving a 14-year-old child. Sexual assault of a child over a 14-year-old. So, there you go.
since then, what we're looking at are offenses of omission rather than commission. He was originally, the first one occurred just a few months after placing on probation in 2012. It looks like everything was done fine until 2016, some 4 years later, when we had another issue. It's now been 7 years since that. Granted, he's not doing exactly what he's supposed to do, but in view of the fact that he received 2 years
How old are you?
TDC.
How old are you?
46.
Yeah. At his rate, we'll see him 4 or 5 more times before
Well,
his natural life.
I don't think
At
so.
this rate of consistent misbehavior.
It's, the point is he got 2 years the first time, 3
Yep.
the next time. This is, as Mr. Ham pointed out, incrementally a whole lot more than.
And how's that working?
Circumstance.
How's that deterrent?
We're going to find out after a 10-year sentence.
No, it should have stopped after the first one. I don't take that deal. I think a jury in this county would be more appreciative of making the decision as to whether the minimum of 25 or up to life are appropriate under his consistent misbehavior of a case. And this court is not going to stand for being light on sex offenders, especially when you offend on a child. That is it. Next is what? Tremaine Celestine. We'll set that for trial. Next, Tremaine Celestine, please. Okay, what are we going to do on Tremaine?
It is an unagreed plea on the motion to revoke probation. That is Dan's.
Okay, that being no.
All right, explain it to me.
This is a motion to revoke probation. There is no agreement on this. The only grounds are failure to report community service and being behind on fees.
Do we have a probation officer here on this one? It says felon. Six 22. Well, all I need to know is this. Has he been an absconder for 3 years?
Yes, Your Honor, as far as.
Okay, he just walked off the job on a burglary of habitation, right? And because I'm looking at, I mean, I can add 2 and 2 together here, and it says April 1st, May, June 2020, and then it stops, and then there's a motion to revoke probation filed on June 22nd. So that's 3 anniversary date, almost 3 years, which meant he walked off the job.
In Your Honor, he had originally received a deferred in 2015
You know,
and then was placed on a straight probation in
Yeah.
May 18th, 2019. And
okay,
It's March 18th.
I apologize, March 18th.
okay. What? Of what?
10 years probated for
No,
6 years.
no. How long was he on deferred probation?
He was-
before we converted it.
He was on deferred from 2015 to
Yeah,
2019.
which makes, that's what I do. It's-
About,
That's why it's 6 years probation. He got.
right, it was
credit
about
for
4.5 years he was on,
All right,
that he was on deferred. And he's been on regular probation now since 2019.
I want to
Little
know
over 4
about
years.
when they picked him up. When was he arrested? Does anybody know that?
May 30th.
Where is that?
On the other side, underneath the reset. Probably.
Okay, here's the habeas, okay, but when was he arrested is what I want.
On the 27th,
When did he finally get in custody?
it was 27th of last month.
May,
3 years.
May of
See,
26.
he's gone for 3 years. Oh, okay.
I think it's down.
Yeah, and how did that happen? You got arrested, right?
Oh, yes, sir.
You didn't turn yourself in because you have such a guilty conscience about it all. Somebody had to catch you.
I actually did.
Somebody had to catch you, right?
I was pulled over on a traffic
Yeah,
violation.
okay, and then they had it in the
Let me go.
computer.
He let me go because he didn't run anything. He just gave me a warning from a speeding ticket. But I actually told him what was going on with probation, and he took me in and brought me down because I was in front of my house
I don't know
when he
about
pulled me
that.
over. So
Well,
since I was so close, he
Well, they
gave me a
got you.
warning.
The thing is everything was. You were exposed now. They know who you were. They know where you live. Everything had now collapsed. The house had fallen on top of you.
Yeah.
You weren't going anywhere.
Yeah.
They
Don't take
got you.
credit for it.
It was just a matter of time. But you didn't turn yourself in. This is the thing. You had 3 years to do it. How many days is 3 years? Over 1,000.
Oh, it's good.
1,000 days. Any of those days, 1,000 days go by, and it never bothered you enough to go, you know, there's a warrant out for me. I just can't live with this. I've got such a conscience that is bothering me, but it didn't bother you.
He did.
Yeah, that's why you turned yourself in within those 1,000 days. Well, okay. What do y'all want to do?
We're ready to proceed.
All right. In 15-22743, does the defendant and your Tremaine Celestine,
Yes, sir.
and raise your right hand. You solemnly swear or affirm any statement you make today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your hands. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, this states that on May 18th, 2019, you were sentenced to 10 years in probation, 10 years imprisonment, probated for 6 years for burglary of a habitation. Do you understand what you're charged with here?
Yes, sir.
Is there a probation officer on that?
She's on her way.
Because I'd like a pre-sentence report. Do you happen to have a?
Yes,
copy
Your
of it?
Honor.
Oh, then we can- sir.
Original PSC.
Yeah.
Way back.
Yeah.
2015, yeah.
All right, allegation number 1 states that you failed to report to the probation office on or about April 1st, May 6th, May 13th, May 20th, June 2nd, and June 10th of 2020 in violation of your probation order. Is that true or untrue?
True.
Are you pleading true to that voluntarily and because it is true?
Yes, sir.
Do you understand by pleading true, that is enough? Voluntary and knowing plea of true is enough to grant this motion to revoke probation by a preponderance of the evidence or greater.
Yes, sir.
Your probation can be revoked. You can be sentenced to no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Thank you, Chris. Judge is low-key cranky with probation right now, too. I can tell. He's not saying it, but he's like, damn it, I've got court today. Where's the probation officer?
Okay, go ahead.
Well, Your Honor, again, he's been on some sort of probation since 2015. he reported, since he's been placed on regular probation, he reported, I think, pretty well for about a year. And then COVID struck, and if you'll note the dates that he failed to report began with the onslaught of the bad COVID stuff locally. He advises me that he got out of the habit of reporting, did not follow through with it, and realized that he needs to do that. In his favor, we have no new offenses other than this failure to report. He has a job and he's been successfully working and doing well. We're asking the court to hold this in abeyance, let him continue on probation and be a good citizen, with an admonishment that he needs to start reporting again regularly.
Your Honor, the state would just argue that defendant was given a chance by being placed on straight probation. We just asked for 7 years TDC, Your Honor.
Anything you want to say, sir?
When it all started, the reason I stopped reporting because my fiance, she became real ill. She's been having major surgeries every year since 2019. So it put me on a burner to where I just had to work full time and be a full-time dad. I
What stopped
literally
you from reporting, sir?
it's just the time frame. When
No.
COVID happened, it switched from I think going up there
When
to
was the last
calling.
time you?
Yes,
That's
sir.
been 1,000 days. You
I
couldn't
literally-
squeeze in on your busy schedule,
I-
a little reporting?
I literally been working every day since then, Your Honor.
Thank
Monday
you,
through
Supervisor.
Saturday, and I'm off on Sunday.
Who's been the supervisor on your probation?
Who's been my supervisor? Miss Bruce.
No, you have been.
Oh,
You've been supervising your probation.
yes, sir.
They don't know where you are, who you were, what you're doing, anything about you.
He's in a mode.
And if we've got 5,000 probationers, if everybody did that and thought, well, that's what I'm going to do, what Tremaine gets away with, please, we wouldn't have a job, really. 85% of the people on probation do fine, follow the rules. And
Oh, that's
report
awesome. Thank you,
regularly and
Crash.
do what they have to do. And this is serious. Somebody's home, you burglarized somebody's home and stole stuff. Big screen TV, just all for them. All right, anything else?
Thank you, Susan.
Nothing further.
If nothing further, I'm going to find there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence. Or since or greater, since allegation 1 has been proven true, your probation is revoked. You have already been found guilty of the 2nd-degree felony, sentenced originally or most recently when your probation was revoked the first time, and you were then
Legal Vices. Everybody, go over there and subscribe. It's good times.
found guilty and
Watch Jeff get drunk. Not always.
what were you revoked the
Mostly
first time
Fridays.
for when you were placed on deferred? Because I know the answer to this. I just want everybody to know it. Failing to report. Yeah. So you know how important this was? Your probation is revoked, sir, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal
Thank you,
Justice
Sandy.
to serve a term of 7 years. I think the state's. You got a problem with that? Maybe you shouldn't burglarize people, and maybe when you're placed on probation twice, you ought to follow the rules. You have a problem because you want your rules to be followed. Everybody on this planet has to follow rules.
Ooh,
That's so we don't infringe on other people like you have done illegally. If you don't like that, we can sentence you up to 10 years. Well,
you just gave him to stop breaking the
I'm
law.
looking at this
asshole.
pre-sentence report, and at the beginning, it looked like you were going to be a success on this because you said all the right things. You just don't do the right
I
thing.
can finish.
We don't have to, we're not going to run around and catch 5,000 people. You got to follow the rules, but you were put on notice the first time you were revoked. You were put on notice. This is serious. And for 3 years, 1,000 days, not any of those days did you feel compelled with your conscience to come in and say, Y'all are looking for me and I'm going to do the right thing because I'm bothered. Sir, this is what we call justice. And that's what we're supposed to have for everybody. And you, by your poor actions, set examples as well for others. Don't do this. It has consequences. Yeah, you probably, the sad thing is you probably are able to. You just don't want to.
Yeah, I do.
You made choices, the same wrong choices
I just
that we put you on probation, that we put you on notice for. And if you can't do anything, you got to report, because if you don't, you're not on probation. You're not supervised. And without supervision, you will fail. That is all. August Coleman. Another company. Mhm. There's a deal on this one.
5 years. This is just fair to show change of job status.
Well, wait, he was in. How many? Okay. I see. August Coleman, the third, please.
I don't know if these defendants are seeing the cases in front of them, but
Yes, sir.
they got to know what they're
All right,
walking into.
23 CR 220 is now called the state of Texas versus August Coleman the third. Is that you, sir?
Yes, sir.
Present
Danny.
with Mr. Dusler, your attorney, and you've been indicted here, sir, for the third-degree felony of failure to comply with sex offender registration. And that's another very serious crime that you were convicted of an aggravated nature of a sex crime.
Thank you, Big Kev.
And does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes.
In summary, this states in the indictment that on or about March 1st, 2023, that because of a reportable conviction for aggravated rape earlier, that you were found guilty of, that you failed to report as required with your registration requirements as a sex offender, which is for the rest of your life. You have those requirements. Do you understand what you're charged with? That you don't know that you were supposed to register properly as a sex offender?
Did.
Okay,
Did the time for 2.
You
I
didn't
didn't know.
notify them, you changed.
It's not
the
gonna
job,
work.
Right?
Thanks.
When you were working at Dollar and Moor.
I've been
That's-
working down more, right there, I got a lot of good, I
know, but when you and I talked, the registration officer said you never notified them that you went to work there. And that's the reason you're entering your plea guilty on this.
Yeah, when you change work, you're told that that's reviewed with you. But there's a document that we give to everybody who's a sex offender that shows that you have a duty to register even when you change addresses or work locations. You have to report that, and you've failed to do that as you became employed with Dollar and Moor in Beaumont. And we have to know where you are at all times, even during where you are at work. Do you understand?
I did, on report.
All right.
Later on.
Okay, so you're not guilty of this, sir?
Not guilty.
All right, let's set for trial.
Judge, it looks like he is on probation for this offense
Where from out of where?
out here.
I didn't show it.
It's showing inactive, but everything that I indicate here is that he should still be on probation. So it looks
Everything-
like we need to file a motion to revoke probation on this matter.
Well,
Judge.
then do that, and it's set for trial on this. Monroe Gill, that is all. Monroe Gill,
Gotta go.
how old is he?
77.
Monroe Gill?
They really do. I got lucky today.
Yeah.
He's a little confused about a lot of things, but
Well,
he tells me he hadn't been on probation in quite a while and he discharged it fully and.
Well, do we need a competency? or
No,
something?
no,
Okay.
just as some of us are approaching, closer and closer to that age, we have to take that into consideration.
I know that's a concern to you, but
It is
when I
today.
get your age, I'm gonna be worried about
It
it.
is today, because I got a year and a day ahead like today. And I'm being rewarded by moving these things along.
You're doing, you're serving the general public's better interest.
Judge is even busted on counsel.
Monroe Gale, that's you, sir?
I love it.
22-41167, you're Mr. Gale?
Yes, sir.
You were charged here in this indictment with on or about October 31st, 2022 in Jefferson County, Texas, committing the third-degree felony of evading arrest or detention with the use of a motor vehicle. But that's not the real problem. I mean, that is a problem, but there's gas thrown on that fire because this also states you have a conviction in 2004 and the 252nd.
We need more of them.
District Court next door for illegal possession of a controlled substance. And after that was final, you committed the offense of illegal possession of a controlled substance, a third-degree felony, and was convicted in this court with me earlier in 2008. And what this means is you're looking at really no less than 25 years to life imprisonment. Do you understand? Because you're an habitual felon. All right. I just wanted you to know that.
You know, he's rejecting
Okay,
statement for
well, set it
not
for trial.
guilty.
Yeah,
And
know.
he's also asking the court to consider relieving me and appointing someone else to take it so he can get this resolved as soon as possible.
Is that right?
Can I say a few words?
Yes.
Oh, yes, I got no idea what these charges is.
Your lawyer didn't talk to you about this?
Oh, yeah, he told me what I was charged with, but
Okay.
whatever the charges is.
I have
it
no
wasn't-
idea.
I ain't been in trouble in 15 years. It's been 15 years since I've been around drugs, did drugs or anything. I'm up in here, I'm gonna lose my house, my family leave me out there and I'm up in. I've been
According to this police report, it states that they observed a maroon Kia with a temporary Texas license plate traveling south on Gulf Street. Oh, no, don't interrupt me. I'll just, let me tell you and then you can respond, okay? They activated the emergency lights. After a brief pursuit, they had to chase the vehicle down. It came to a stop. A black male identified as Monroe Gill, date of birth 10/3/1980, exited the driver's seat of the vehicle and began running on foot. He turned, looked at me, and several times through the foot pursuit, I chased after him in my distinct department issued uniform, yelling for him to stop. Gill was unable to be located, but he was identified through paperwork inside of the vehicle. The passenger of the vehicle, the passenger inside the vehicle, and through a driver's license photo of him that I pulled up on the computer. Inside the Kia were two plastic baggies, were methamphetamine. And what he did was he stopped you, he saw you, then he, according to him, you took off after you were told not to, and the driver's license, that picture of you matched the person he saw he was driving. So that's what they say, and that's why you're indicted. So you're going to go to trial. Good, that's okay. You're looking at, if convicted, no less than 25, no more than 99 years confinement or life imprisonment if all of this is proven true.
So you're capped at 90.
Dusler can certainly help you. He's a
Which is
fine
nice.
lawyer, but it would go to trial quicker if you elected to release him. Is that what you want to do?
Yes, sir.
Then the next lawyer on the trial docket wheel will be appointed to represent you, and we'll place this on the trial docket. He has two cases?
Yes, sir.
Okay, the other case is 23-573, and it's from the same event. It's illegal possession of fentanyl. Well, that's a terrible thing.
Ouch. Yeah.
It shows that.
Yeah, Judge, I've stayed out of trouble for a while, but when they caught me, I happened to have fentanyl on me. That's a tough sell.
This indictment, in fact, includes 3 prior convictions that you were convicted of: illegal possession of a controlled substance in 2004 next door, illegal possession of controlled substance in this court in 2008, but also you have another one, illegal possession of a controlled substance conviction out of Chambers County in 2012. So you're even more a habitual felon if all of this is true. All right, both of those cases will be set for trial, and the next person on the trial docket will be appointed to represent you, and that will be set for trial. That is all. Jacob Holland. What are we doing on Mr. Holland?
Well, you're on
You have one case?
one thing.
It's the end of the 12th.
Huh?
We did the paperwork, well.
Yeah. This whole call could be summed up with this.
Okay, that'd be a no.
Are you Jacob Holland? Are you Jacob Holland, sir? Okay, come on up.
Yeah, I'm behind the
We
live.
call now cause number 23-CR 165,
seen it,
state of Texas.
tell me when
versus
it
Jacob
dies.
Sean Holland, you're Mr. Holland. Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here and proceed in summary?
Yes, sir.
In summary, this indictment, which was handed up on April 26th of this year by the grand jury, alleges that on or about March 9th, 2023 in Jefferson County, Texas, you committed the 3rd-degree felony of assault of a family, household, or person with whom you have a dating relationship, and you impeded the breath or circulation of the victim by squeezing the victim's neck. And you intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the victim.
Oh,
You understand what you're charged with? This is a 3rd-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison, probated for 10 years, fined $500. Is that your understanding of the agreement?
I wasn't told 10 years in prison, I was told 10 years probation.
10 years in prison, probated for 10 years. That's what the judge explained to you. I did as well.
Okay, do you understand? You're looking at no less than 2 nor more than 10 years confinement in prison if convicted. To be placed on regular probation, you are convicted, sentenced between in a number from 2 to 10, then that sentence is suspended and you're placed on probation. Is that your understanding of the plan? And fined $500? If I follow this agreement, you have no
it's
right
only
of
called like
appeal
a
of your
fine for the
case. Do
day.
you understand?
but it's fantastic.
How do you plead to this, guilty or not guilty?
I plead guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Did you understand it? Discuss it with your attorney, or the contents all true and correct? Yes. You have to speak out. Yes, sir. Okay. State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. So help you God. Is that so?
Yes, sir.
How much time does he have, please? The pre-sentence report waived?
Yes, sir. Yes.
Anything else to add on
No, sir.
this? If not, I'm going to find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That term of imprisonment is suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be terms and conditions of probation which are normal and customary for this.
That's right. It's the system.
As a condition of probation, you shall serve 90 days in the county jail. You have 54 days credit. But I can order up to 6 months, 180 days. I'm going to order you to do 90 days in addition. That is because of the nature of this offense. Anytime somebody squeezes somebody's neck, that is essentially an attempt to kill somebody because it impedes the breathing. And we all know what's all about that. You're going to have to control your emotions when you have a problem. You understand what has happened today? Please add that to the, and that is ordered to be served day for day, beginning of meeting. That is all.
Yes, sir. Please.
Latoya Ivory, please. Hey, John, you got a full day here this morning, huh?
I do.
You got a whole page with your name there, a whole page. 22-39865 is called Latoya Louise Ivory. Present with your attorney, Mr. Dusler, and the state's attorney. What are we doing today?
It's a play, Your Honor.
Does the defendant waive a formal reading and arraignment of this indictment 22-39865, which charges you with the state jail felony of theft of service? Can we proceed in summary?
Yes, sir.
In summary, this indictment states that on or about November 27th, 2021 in Jefferson County, Texas, you committed the state jail felony of theft
I'm watching this
of
cold.
service involving a Toyota automobile and a rental agreement surrounding that particular vehicle. Do you understand what you're charged with?
Yes, sir.
If convicted of a state jail felony, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
And an agreement has been reached here where you would be pleading guilty, sentenced to 2. Is that 2 days, 2 months, or 2 years? 2 years, okay. And then you would be placed on probation for 5 months or years.
5 years. Sure.
No fine? Restitution,
Just
though.
restitution.
There's no fine, but restitution is ordered in the amount of $15,986.34. Is that your understanding of the agreement?
He said that he's asking you if it's the agreement, if you understand the agreement, 2 years state jail, but that's probated for 5 years. No, and the restitution ordered if they do not recommend you.
Yes, sir. Yes, sir.
You're gonna have a job to pay this money back, because it has to get paid back.
Yes.
It's a condition of probation. If you fail to pay it back, you can be revoked.
Yes, sir. I have a job ready.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
15 grand. That
How do you plead to the state jail
not
felony
likely.
charging you with this theft of service, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Show you what's marked as State's Exhibit 1. Did you sign that voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into
No
evidence
objection.
without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and in any lesser included offenses. You're giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. So help you God, as that's.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Without objection,
No objection.
it is admitted. Pre-sentence report is waived.
It is.
correct? All right, nothing further. I'm going to find as follows this. That you were pleading guilty to the state jail felony voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt.
Yes, sir.
No, it's 5 years probation.
Oh, sorry.
I'm gonna change.
I might have missed it, but I don't know what she did. Whatever it was, it caused $15,000 damage to somebody.
I now find you guilty beyond a reasonable doubt of this state jail felony. You are hereby sentenced in accordance with this agreement to confinement in the state jail for 2 years. That is suspended and you were placed on regular probation for 5 years. You must pay restitution in the amount of $15,986.34. And there will be other conditions of probation, which are normal and customary for this type of offense. If you fail to follow the probation, your probation could be revoked. It could be found guilty. I'm sorry, you're already found guilty. Your probation could be revoked and you could be sentenced up to 2 years in state
There's
jail. Do you
no way
understand?
you get away with that. No way. You go and give all your information and then you take off with the car. Sweet Jesus.
Anything else on this?
No, sir.
Okay, please see the probation officer, thank you.
There's nothing.
No, fine. Okay, Henry Green is next. Is Ralph Kimbler here? Ralph Kimbler's,
Get reset. That's the one with the Langston with the 15 days going.
why is that reset?
He has 2 new cases. He assaulted guards at the jail,
Okay,
and they're going to be his highest charges, Judge.
Robert Henson, and then that Henry Green is reset. Robert Henson is with Aldwin Samuel. Is Aldwin here?
Yes, sir.
Ronaldo Garza. Mr. Sanchez, you ready?
Yes, Your Honor.
It's good day to you.
Thanks, Doc.
It's gonna be a plea whenever.
I need Ronaldo Garza, please. Henson is passed.
Thank you.
No, Andrew mostly sits down.
Here is this, a little paper for Ivory. Thank you. What are we doing on, please on both cases?
It's a plea on one case,
Which
Judge.
one?
39569.
Okay. And so 7-0 will be dismissed as part of this, is that right?
And the registration paperwork was submitted through the tablet to you, so you've got it.
Okay, we call now 22-39569, the state of Texas versus Ronaldo Garza Jr. Are you Mr. Garza?
Yes.
Present with your attorney, Mr. Sanchez, and the state's attorney. Does the defendant waive a formal reading of the indictment here in 22-39569? Can we proceed in summary?
Yes, Your Honor, and yes, sir.
In summary, this indictment alleges that on or about March 14th, 2021 in Jefferson County, Texas, you, Ronaldo Garza Jr., committed the second-degree felony of sexual assault of a child. Do you understand what you were charged with here?
Yes.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison, and cause number 22-39570, another second-degree felony of sexual assault of a child indictment would be
Oof.
dismissed. Is that your understanding of the agreement?
Yes.
If I follow this, sir, you have no right of appeal of your case. Do you understand?
Yes.
Sign that page right there. Here. That's a better stylus to use.
Well, yeah, it's a felony docket. That's pretty much what that is.
Thank you. Again, how do you plead to the second-degree felony charging you with the sexual assault of a child? Guilty or not guilty?
Guilty.
And are you pleading guilty voluntarily and because you are guilty of what this alleges? Yes, we got it. All right, show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Did you understand it? Review it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
Admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of this crime and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true and states, so help you God. Is that so?
Yes.
State's Exhibit 1 is made a part of the record for all purposes without objection.
No objection.
Is a pre-sentence report waived?
It is waived, Judge. We're ready to proceed. Our only argument is we're asking the court to accept the plea agreement.
Okay. Now, one other thing is a conviction of this offense as alleged here subjects any offender to registration requirements under Chapter 62 of the Texas Code of Criminal Procedure. Do you understand that?
Yes.
And we're going to go over that here in a minute. And I'm sure your attorney has talked to you about it. This needs to be filled in up at the top here in a minute, but in fact, here, you can work on that. If nothing further to add here, I'm going to find that you were pleading guilty today voluntarily, Mr. Garza. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years, correct?
Yes, sir.
That's what, and here, there is, I'm going to get into that. I'm going to show you what is a sex offender registration. Did you sign that document? Did you understand it? Discuss it with your attorney? Or the contents all true and correct? You have to speak out. All right, thank you.
Did you see the beginning of the call and see what happens when you don't follow that?
This sex offender registration is before the court. I see your signature here. And this states as follows, that you have a reportable conviction or adjudication now of an offense that is required to have you register as a sex offender. And this further states under your signature that you understand that you have a reportable conviction or adjudication requiring you to comply with Chapter 62 of the Texas Code of Criminal Procedure, sex offender registration. Failing to do so is a criminal offense that can result in prosecution. If you move to another state and have similar reporting requirements for sex offenders, you must register in that state as well. Failure to register will result in you being charged with a criminal offense. Do you understand what this is requiring of you, sir?
Yes.
All right, then this is made a part of the record for all purposes. All right, anything else to add on this?
No, Judge.
Then we are in recess on this case. Thank
I'll
you.
follow that dismissal on the other case, Judge.
Okay,
He did have some significant jail credit, Judge. He just wanted.
he gets credit under the law for all time served in connection with this offense. That's a fact. But I don't know what it is, but he would be given credit, and the coordinators calculate that along with the jail, and they're always they're pretty accurate. Do you have an idea right now?
No. But I will have it. It's, I have to look up other things. I'll be telling someone else it looks like.
Okay, yeah, it looks like he was in custody somewhere else as well. In this case, so all of that gets added together. And they're pretty good. They're very accurate. Everything's on the computer, and then we never have problems with it. And if there is a problem, we'll look into it, but it never happens. It's arithmetic, and the computer says what it says, and we never see mistakes in it. So, but anything can happen, and if y'all decide that there's a problem,
Yeah.
we'll look into it.
Thank you,
Yes,
Judge.
sir.
Thank you for working.
Thank you, sir.
Schedule.
Okay,
Process.
Mr.
Good day.
See you. Take care of yourself.
Uh,
Corey Gooden, Tom Burbank. Corey Gooden,
I know.
certainly is. I guess we need him.
Yeah, we're probably not happy about that.
And he had the.
Here's Garza's other
Thank
case. Might need somebody out there to work to pay for the lawyer. Am I adding that up right? Twenty-two 39599 is called the state of Texas versus Corey Manning Gooden. You're Mr. Gooden,
Yes, sir.
present with your attorney, Mr. Burbank, and the state's attorney. Just briefly, you were charged here, just to remind you, that there's an indictment charging you with on or about December 3rd, 2021 in Jefferson County, Texas, committing the third-degree felony of evading arrest or detention with the use of a motor vehicle. Also, paragraph 2 of this indictment alleges that in the 252nd District Court next door in 1997, so long ago, 30 years. No, that's 26 years. Next door.
30 than 20, Judge.
In the 252nd District Court, that you were earlier convicted of illegal possession of a controlled substance, a second-degree felony in that case. So if all of this is true, this third-degree felony can be enhanced to a second-degree felony. So you're possibly looking, if convicted of all of this, no less than 2 nor more than 20 years confinement.
Ooh, you're in the
prison
bonus round.
and a fine
Congratulations.
up to $10,000. Do you understand? What is your bond right now?
250.
Huh?
GPS.
Uh,
I'm reading the probable cause after there. Do you have a copy of this?
Oh, yes, sir. I'd like to make some comments, Judge.
You always do.
Oh, that's just not good. Judge Stevens is just taking this in.
Okay. Your motion, go ahead.
It is, Judge. We'd ask that the
Good luck.
bond be reduced down to a proper amount. We're asking for a maximum of $50,000 off the 250,000 or less if the court would consider. I would point out to the court some of the things that I see in the probable cause affidavit. One is that it must have been some type of undercover operation with whoever may be the confidential informant. Probable cause to stop him was approximately not that he didn't signal.
Where's that? Is it coming up?
But that was within 100 feet with this kind of suspect in reference to how somebody that is supposedly chasing him is able to say that he was within 100 feet of intersection. But what is inquisitive about this probable cause, Judge, is they positively identified him. Then in the last couple of sentences in probable cause affidavit, not once but twice had a photo vinyl or some type of photo ID to make sure it was actually him or possibly him that they saw. If they were so sure at the time, they wouldn't have to not just one but two confidential informants that see whether or not is this the person. So we would ask.
I haven't seen this yet, but I mean, this attorney's trying to. It wasn't my guy. They don't have an ID. I don't know. I don't see that ending well.
Yes, Judge, that you reduce the bond. This invading, I think, was enhanced. Well, because one was a motor vehicle, but it wasn't another motor vehicle conviction. I think it was a misdemeanor invading sometime before. That was enhanced on this, and he did not realize that he had a form at the time. He does have a GPS. He was over in Harris County.
What is your address?
6811 Greenwood Chase.
Okay, you mumbled. I don't, what I have here is 7615 San Diego. That's not right.
No, sir.
Did you ever live there?
Yes, sir.
Okay, you know, what's your address when if you left
That's what
jail?
they're trying.
6811 Greenway Chase.
They're trying to set up an alibi with his GPS, which I'm not buying already. I don't know. I haven't seen this.
Is that an apartment number?
Yes, sir.
What is it?
6811
Oh,
Greenway Chase.
Is it a house or is it an apartment?
It's a town.
It's a townhome,
Yes, sir.
so it's not an apartment, it's a townhome.
okay, okay. There's no number after 6811.
It's not an apartment.
There's not a unit number. And it's Houston,
Yes,
did you say? What's a zip out there?
selling
You're having trouble with it.
two. Should be 775.
He probably doesn't send mail to himself.
Yeah, I know what my zip code is, but how long have you lived there?
2 months.
Okay. All right. Okay. Where did you live before that?
San Diego and Willis.
You're mumbling. I can't.
San Diego and Willis.
Okay, 7615
Yes,
number.
sir.
How long did you live there?
You're gonna have an address
long
in
time?
custody
Yes,
soon.
sir.
I'm guessing.
What station?
Judge, since he has a prior running from the police officers and he did this time, as far as the ID that Mr. Burbank brought up in the police, how do you know that?
Yeah. Okay, let's see.
Let's see,
Okay,
here's a
I checked
misdemeanor evading
criminal
detention
history.
from,
There were prior convictions for evading in a motor vehicle.
yes, sir.
which enhanced the evading charge.
Well, there's a prior evading on foot. I know that we have a conviction for that.
What year was that?
That was in 1998. And then he got the possession that he got sent to the prison for 97. Then he got another charge of evading in 2013 and was convicted. Had 60 days on it in 2014, October 3rd of 2014.
So how many, and what's the grand total of evading?
So he has 2 and then this new charge. So he has 2 prior evadings running from the
Thank you,
police.
Penny.
And as far as the ID in the police office report, Detective Raymer says when he was watching him when they were doing the surveillance on him, he recognized Gooden. The only reason he had the confidential informant identify him is to find out if Gooden was the same one they were talking about as 2-story. That was the nickname, the street name that he had. But Detective Raymer recognized Gooden before the chase took off. So,
Well, I would agree with that, but that's suspect because then the other detective that was there too also had to see whether or not it was one and the same person. So there were 2.
just to verify whether he's 2-story, not the guy driving the car. Judge, since he's run from the police before, he has a flat risk. We think the bond is sufficient. If the court does decide to reduce it, we'd ask that a GPS be put on him.
He has a GPS, Judge, already that's ordered. And these have been one in the 90s. The other one was almost 9 years ago.
This guy's the very definition of flight risk.
But we got another one now, and we've got a 3rd-degree felony with an enhancement charge. I'm going to give you some relief, but evading arrest or detention using a
Thank you.
motor vehicle is just compounds the seriousness and the threat to everybody who's trying to drive on the road responsibly. But between the similar criminal history and the circumstances of this case, I'm going to reduce this bond to $125,000. I'm halving it, but he has to have a GPS. He's going to have to be on home confinement. He'll be allowed to be released only to go to work and back in the most direct route possible or for medical necessities. He will also have a drug patch because this is involving a history of drug usage. And
He will also stay out of Fulton
we're gonna
County.
load him up with materials and checks and balances to ensure that he is not a threat to others and a harm to others by further irresponsible actions. You're too young to be having all this criminal history. And then these are very serious circumstances. And they say that's you. And the indictment is a probable cause finding that is you. Did you have any kind of job?
Sir,
Do you have any kind of job?
I wasn't working at the time.
Well, sir,
No, sir.
You
Not at
weren't?
the time.
of the arrest, you weren't employed? But this says you're driving around in a Maserati. I can't get a Maserati.
That's not me. but-
Okay, well, that's what we go to trial. That's what that's all about. Anything else set for trial?
Yes, sir.
All right, set for trial. That is on.
If you don't have a job and you're driving a Maserati, you might be a criminal.
Next is Lorenzo Carmona. John,
I mean, it's not for sure,
just here.
but the odds are definitely higher.
Next is, who's ready on something?
Thank you,
Done with
Kristen.
everyone but Mr. West.
Is Audwin not?
Didn't get an answer. Or a text.
On Henson, Who's that? Well, John West isn't here. We may not.
Oh, the hits just keep coming here.
Well, he needs to be up here. On Robert Henson, stand by.
Oh, thank you, John.
On Robert Henson, we have received a report, and this is Alderman Samuel's case, a report in from Dr. Grapan that states that the defendant is competent. So
Yes, sir.
I'm going to allow Mr.
I didn't
Samuel to
catch that.
sound in,
Was it a
but I
Mazda?
can't wait on him. We're going to move forward.
There's a big difference between a Mazda and a Maserati.
Samuel this morning after we got that report and talked about it.
That
He
would be
was gonna
funny.
ask for 2 weeks so that he could go over an offer that's made to his client and review the case with him.
Okay, on this date, the court is receiving this subject to any objections that the defense may have. They were supposed to be here an hour ago. They're not here, but we're moving forward. Haven't heard anything from him. And this is court's exhibit number 1 is the doctor's report in that case, finding the defendant competent to stand trial. And we will set this for trial. That's Henson. Robert Henson can go.
Yes. The ever so rare Maserati. That's where they just take a Sharpie and add a couple more letters.
39570 numbered case is dismissed. And it's like John, I'm waiting for John West on cases. We are in a recess.
Well, that's no good.
This is right on.
Yes, sir.
What are we doing on this?
Set it for trial. Talk about client problems, sure.
Well,
Layered.
that's what's fun about being behind the call. Come on in, defendant. Judge in a great mood. You're going to like this. My suggestion, don't push your luck with your requests. Oh, thank you.
2 cases are now called 23-CR21 and CR-25. The state of Texas versus Stephen Adams. You are Stephen Adams, present with your attorney, Mr. West, and the state's attorney. Okay, you were charged with first-degree felonies in each case. You are facing, if convicted in each case, no less than 5, no more than 99 years confinement or life imprisonment. And
somebody was bad.
$10,000 for each case. Do you understand?
Yes, sir.
All right, Mr. West.
We were requesting this be placed on the trial docket, Your Honor.
Okay. And it will be placed on the trial docket. Are you appointed on this?
Yes, Your Honor.
Okay. And you're going to handle it then on trial?
Thank you.
Up to Mr. Adams.
I can if you need to.
So he's a good lawyer. Or you still have, do you still have zero income?
And so I got no income at all.
That means zero, right?
Right. It's-
And then that'll be set for trial as soon as as possible, okay? Thank you. Here, John, here's Brandon Bonton.
Okay, yeah. No, hang on to him.
Hold on. He doesn't.
All right, who's our lucky new
23-41514 is called the state of Texas versus Elbert Cox. You are Mr. Cox,
Yes, sir.
present with Mr. West, your attorney. You were charged here with a third-degree felony of failing to comply with sex offender registration. You face no less than 2 nor more than 10 years confinement in prison. A fine up to $10,000 can be assessed.
You also have an unfortunate last name for the purposes of my chat.
And probation is not an option, I guess, since he has this underlying serious felony conviction. It is alleged of aggravated sexual assault. What are we doing on this?
Set it for trial, Your Honor.
All right, it will be set for trial as soon as possible. I think try to get one of the other judges to help me on this so we can get this done as soon as we can. I think that would be a succinct trial.
Yes, sir.
Seems
Your Honor.
like. And let's get this done. Okay, we'll move it as fast as possible. That is all. Dylan Garner.
That's when you plea, Your Honor.
Okay, thank you. Dylan Garner, one case, correct?
Yes, sir.
23-41463.
I believe it's the GTFO.
We still under a heat advisory?
Yeah.
Feels like it.
I'll tell you, it's killer out there on.
It's bacon.
My father used to have a saying, God bless him. He said, I know hell is going to be hot. I just pray it's not humid. He said, I can take that dry heat down. He said, but man, I appreciate what he said because I tell you, it was just like, you know, you're in a one of those saunas out there.
Yeah.
Okay,
we're freezing here,
23-41463 is called the state of Texas versus Dylan Garner. You are Mr. Garner?
Yes, sir.
And I need a pad, I think. That comes in handy on, please. And you're here with your attorney, Mr. West. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about January 2nd, 2023 in Jefferson County, Texas, you committed the third-degree felony of assault family violence by choking. Do you understand what you were charged with here?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Sir.
An agreement's been reached where you would be pleading guilty, sentenced to 5 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this third-degree felony, sir? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty? John, help me.
Oh, I'm
Here,
sorry.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that?
Yes.
Did you understand it? Discuss it with your attorney? Or the contents all true and correct? State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You were guilty of the crime charged and any lesser included offenses. You're giving up the rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so? Yes. This is, States Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived in?
Yes,
there?
sir, please.
Anything else to add?
No,
I
sir.
will follow this agreement and find you, sir, are pleading guilty to this indictment voluntarily. You're mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here into this hearing to support your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony as charged in this indictment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. That term of confinement is suspended. You were placed on a regular probation for 10 years. There will be terms and conditions of probation which are normal and customary for this type of offense that you must follow and abide by. You also shall be ordered to pay a fine of $500. If you fail to follow these terms and conditions of probation satisfactorily, the probation could be revoked. You could then be sentenced to no less than 2 nor more than 5 years in prison. Do you understand the consequences here, sir? Also, the judgment shall reflect that this conviction involves family violence by choking. Okay, is there anything else to add on this?
No, sir.
Then that is all. Please see the probation officer. Thank you. Akeem Harrison.
Yeah.
What are we doing?
Problem.
Everybody must drop.
Yeah, you can't do that.
I've got quite a few.
Did we do, Collins?
Tom's still over here. He's right here.
Okay. Sorry.
Do we have more contestants?
Oh, yeah.
Let me look.
Akeem Harrison.
Oh, indeed we do.
Right phone.
Now, Boris Collins, you said that's a problem, right?
No, that's gonna be a plea.
Same phone.
Go ahead, put a line for that. Put a line for that. All right, 23-101 is called the state of Texas versus Akeem Harrison. Is that you?
Yes, sir.
Present,
Spread it up.
his attorney, Mr. West, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
Yes, but we're gonna place this on trial. Not
Oh, okay. You're charged with the second-degree felony of robbery, sir, which if convicted, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the potential consequences here?
Yes, sir.
All right. You talked to the complainant about this one?
I have not, Your Honor.
Well, let's not make this futile. You know how things have been lately.
Yes, sir. I'll talk to him.
They have a relationship at the
Understand it.
time of this.
Yes, sir.
And which is what causes some of the complainants to lose their memory
Yes, sir.
as we get close to trial. And either they're gonna, I don't want to waste the time. Either they're gonna back y'all up or not.
If you reset it, you want to reset it a week, I'll
I just want to know.
talk to him.
I want to know because the the grand jury relied on the complainant, but you know what has happened lately? Is
I mean,
people
if you want to reset it,
support
you'll reset it 1 week, I'll talk to him.
the grand jury's indictment or the DA's office or the police. When they ask for help, they get the help, and then we come to trial. And all of a sudden, there's this communication being done behind the scene, which is inappropriate. You do understand that. You cannot have any contact, nor anyone on your behalf have any contact with the victim. Do you understand?
Yes,
If I do,
I'm sorry.
let me finish my speech.
Okay.
If I do, and I'm not just saying that because it doesn't happen, because it happens too regularly. If I find it, people will be held in contempt of court because that's a court order, and you can be placed in jail up to 1 year, and also you can be charged possibly with interference with an investigation or a prosecution, which is a crime. We let people ask for help. We rely on that. Money, time, effort is spent, and then we let the process, which is the law, work it out. People doing it on their own, that's chaos. You might as well be living on another planet. We have laws that everybody has to follow them, or else people get held accountable, including me. I'm going to follow the law and the rules as well. People working outside those rules, that's where they get in trouble. Anything else?
Yeah,
It
Your
would
Honor,
be set for
I
trial.
think I'd like to request is first of all, whether you're going to keep me on as his attorney, we need to figure that out. And second of all, I would request the court to evaluate his bond, see if we can get that.
What's his bond now?
Current bond.
Well, what's the amount of bond? Everybody?
8,000.
I did a video
He's gonna make
Well,
that.
it's
with Deborah Davis on his call.
pretty low for a second-degree felony. I'm reading this.
I think the thumb says misuse of the system or something. He goes on an epic rant about this very topic. It's fun.
I'm not sure. Under these facts, I'm surprised using spraying allegedly an aerosol can of starter fluid into a victim's face is not a deadly weapon.
Yes, sir. That's
That
close.
could have been
Yes, sir.
aggravated. First, I'm surprised especially this is in the
That is the problem, isn't it?
complainant's home. After it is alleged the defendant knocked on the door, grabbed aerosol can of starter fluid, sprayed it in his face, then struck the victim in the head with the can before grabbing his wallet and keys. The defendant fled the apartment, ran to and hid in a parking lot of a nearby apartment complex. The victim went out to look for the defendant, found him at the apartment complex. While on the scene, it was discovered that the defendant fabricated his story. Search of the parking lot revealed a yellow colored aerosol can of starter fluid stashed in the open bed of a truck. Victim recognized the can as the one that was used to assault him. The defendant was arrested and booked for the charge. All right. One way to commit a crime. That's one. Okay, it's set for trial. Mr. West is a fine lawyer. He can represent you for trial. It can probably go to quicker if you agree to release him. Are you able to hire a lawyer?
I am. I'm able to. It's just me and my mother. I take care of my disabled mother. I do work. I'm licensed.
Wait. How do you work if you're in jail though?
That's what I'm saying. I was working. I'm not able to work right now at this moment because I'm in jail.
Well, your bond is $8,000, right?
Correct.
Okay, that's a very low bond. You couldn't even.
I
Okay.
don't have anyone in the outside of us as a resource to cash a check for me, cash my checks.
Oh Lord, I had to put that on normal to hear this voice.
Okay, so you have
I
independent
needed to know how much of that was
assets
from being
where
spread
you
out.
can afford to hire a lawyer.
I really did.
Yes, sir, I do.
It's normal now.
Okay, let me see his bond. Did I get it back? There's an indigent fee here, an indigent affidavit that you swore under oath, and it says
But
that
not
your
nearly
take home
enough.
pay is 1,300, and then you have food stamps, but those are the only assets you have. This was sworn to in front of a judge, and
It is now.
you say you have assets that aren't on this, that now you want to tell me about, that you didn't include on this when you were arrested?
Oh, I didn't know that I was, I didn't know
Uh-huh.
I was put that on there at that moment, at the time. I didn't know, I'm not sure. I didn't know.
Well, it says all your assets right here. In fact, the
Okay.
judge works with you, the bonding judge works with you, but this, we rely on this. I mean,
Okay, well, I didn't know, and it's all new to me, Your Honor, so,
well, but what's not new to you, I'm sure, is honesty and truthfulness and forthrightness.
I'm being honest.
Well,
with
this
you.
isn't on here. You say you have monies, but that's not included on here. We rely on that. We appoint people. If you can hire somebody,
Mhm.
we'd rather you hire somebody with when you get in a mess like I do, everybody gets, you gotta pay for it to get out of your own mess. It's just one of the things that comes with life. Other people don't pay for the mistakes that you may get involved in. So
Big dummy's trying to flex. Now it's biting him in the butt.
if you have money out there, I expect you to pay the government back for the representation that the court-appointed lawyers. This isn't a free ride,
Correct.
Okay, all right. So you have money in a bank or something? Is that what you have?
No, I have like paper check.
How are you getting paper checks? When you're
Yeah,
not
let's
working?
have money somewhere,
I
dude.
work for my disabled mother at this moment.
Yes.
And I get
Well, but how do you do that when you're in jail? You're
Well,
getting money for not doing work?
No, that's not this moment. Before I got to all this
Okay,
finesse,
all right,
I had
all right. Until you get out of jail, you don't have an income.
correct.
Okay, so you're full of crap.
My understanding is a little bit. I have stuff with ADHD. I'm sorry.
And Judge, I just spoke to the complaining witness by phone. He still has the same phone number. He's willing to prosecute, and he made sure we updated all his information.
Okay.
Fantastic.
You shall have no contact with that victim, nor anyone else. Do you understand?
Yes, sir.
I find out about it, then you will be held in contempt of court, and that could result in a further prosecution. Don't, you got to follow the rules like everybody else has to, and you get held accountable when you don't. So we'll set this for trial again until such time you can find money to pay. Then I'm going to follow this affidavit of indigence and continue to appoint somebody. Do you understand?
Yes,
Mr. West is a fine lawyer. He can represent you at trial. It'd probably get to trial quicker if you agree to release him, but that's your call. What do you want to do? Keep him, or I can put the next person on the trial docket wheel, and it would probably get to trial quicker. If he had to try everything that he's set for trial, it could be a while because he's in demand. But you've been assigned to him and he's your lawyer, unless you want somebody else.
No, I would like him. If he can help me out with
This one shouldn't take long. I'm looking at the facts, so let's try to move this one as fast as we can. We can move this one, okay? That is all set for trial. Josu Hernandez, please. Josu Hernandez, am I pronouncing that right?
Josue. Yes.
Oh,
Okay.
please tell me we don't have an
Josue.
interpreter.
Josue, I'll be doing. Let's wait. He's got a prior. Did you know that? Okay. What are we doing on this?
He also wants a trial and a bond reduction.
Good Lord.
Plus, since 25,000, I know almost everybody had the same response
Well,
for me,
okay.
but
All right. There were a lot of crimes being committed around here.
Okay, that being no.
The state of Texas. How do you pronounce your first name?
Josue.
Josue? Josue. Arturo Hernandez. Okay. Perfecto. Very good. Habla español. Perfecto. All right. You are Mr. Hernandez, and you were here with Mr. West, your attorney. You were charged with a third-degree felony of evading arrest or detention with the use of a motor vehicle. You also have a prior conviction of theft out of the 138th District Court in Cameron, Texas. If both of these allegations are proven true, you are facing, if convicted, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Do you understand?
Yeah.
All right, Mr. West says you want this set for trial, right? See, trial,
Yes.
you're not certain?
I need to talk to my family again. Well,
Well, was an offer related
Yes,
to
yes,
him?
we've made an offer and I've talked to him about the
Okay.
offer.
What was it? Just for, I'm curious.
Just for
5
giggles.
years.
You're looking at him. Is that right?
Yes, Your Honor.
No, you're standing, okay. See, you're not eligible for probation if you're convicted because you have that Cameron County conviction. So you're looking at no less than 2, no more than 20 years confinement in prison
Things you should know.
if convicted.
I'm feeling conviction coming on. But I don't know.
5 years. What's the but it's in the third degree.
Right.
It's not a second degree.
It can be enhanced to second
What
degree.
is the
Right? But still staying on the range of punishments. I mean, 5 still in both of those. 2 to 10 and 2 to 20, 5 still in the middle of that either way.
That theft, you're standing by that theft conviction. That's a valid conviction.
Yes, Your Honor.
Oh. Well, that's what happens in United States. You're punished for the crime you commit and criminal history, your criminal history. So if it was just this one, you could be eligible for probation, but you're not eligible because you've been convicted before of a felony. That puts you in a bad spot. Where is the you see where the legislature did away with temporary tags?
I read something about that.
Well, that was kind of going out of hand. That was getting out of hand. Maybe that'll help things. Stand by. Holding cell. And so we'll reset this as Mr. West will talk to the defendant about some developments. You know, I hit one of these buttons, John, Dennis, this white one, and I can't remember. Is it pushed in that this is the white one? The white one. You push it in. Well, it's pushed in. That means it's now being broadcast back there, right?
You're on. You're on,
Well,
Judge. And let's
Can
talk
we
with
figure
Mike.
out which
Oh,
one
good.
it is? Because I think I pushed this in and I need to know if y'all are. Thank you. There's not a indicator one way or the other on this.
Yeah. You know, so we'll hang out on there if we believe on running that back.
Holding cell. Test 1, 2, 3, 4. 1, 2, 3, 4. Holding cell.
Test 1, 2, 3, 4.
Test
Holding cell.
1, 2, 3, 4, 5. Holding cell.
I don't know why
Holding
I'm
cell
doing this.
test. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Holding cell test. 1, 2, 3, 4, 5. Test 1, 2, 1, 2. Holding cell.
You're on, man.
Holding cell test.
John.
Don't worry about it,
Yes,
Judge. I
please.
mute myself all the
Hang on,
time.
sorry,
Just
hang on.
keep rolling. Keep rolling. We hear you.
Holding cell test. Holding cell test. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Holding cell, holding cell.
Holding cell.
Are you thinking Dennis is in there?
Yeah,
Is
we're
that a code word?
We're disco. You mean I'm
You're trying to hear, you're in.
Has landed.
You heard in the-
Yeah. I thought that's where he was headed. We're gonna, and I take back everything I've said.
The holding cell dance
Holding
remix.
cell test, 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Holding cell test, audio test, holding cell.
It's not being broadcast.
They can't hear you. So.
Okay. Okay, who do we have next, John? Is it Mr. Jones, Derek Jones?
Yeah, we're bringing it. Got Fuel Jones,
What are we doing on Derek Jones?
trial runner.
What don't you have a trial?
Mr. Collins right here is in the play.
Well, let's bring him up.
Okay, yeah, Mr. Collins. Yeah, I got a couple that are gonna play.
Is this Boris?
Boris Collins, yes.
What do we need?
It'll be Derek Jones.
Oh, Derek Jones will be reset. I'm talking about Jock Fuel Jones. Derek Jones, we're gonna reset for a little bit later for to go over the discovery with him and negotiate a little bit.
Okay, Derek Jones is
so we just
reset.
Yes,
Jaquil Jones.
that's gonna be a trial.
All right, we're gonna need Jaquil Jones out, please. I need Boris Collins though right now.
You're
Yeah, we got Boris Collins. We can take care of this. And then we'll go
He's
to
just contacted.
the other Mr. Jones next. We have two cases here. Is he pleading to 2 or 1?
both are.
We have two cases here, 23 CR 310 and 23 CR 311, both styled the state of Texas versus Boris Collins. You are Mr. Collins?
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, Your Honor.
What are we doing? Because I've got one state jail felony that has several prior convictions. Another state jail felony. Can't understand.
Judge, with the evading, you're gonna need the paragraphs to the jurisdictional paragraphs, so you'll need paragraphs 1 and 2. And then the bullet points, and then with the
Well, you don't have any bullet points on 310.
on 310, you only need the first
Okay,
paragraph.
Gotcha. So we've got paragraphs 1 and 2 of 311 to constitute a state jail felony.
Right.
And then paragraph 1 is a state jail felony on 310, correct?
Yes, sir. And
So is that all we're doing?
yes, sir. And the enhancement paragraphs actually don't have any real effect anyway. They're not properly enhanced. Not that it matters.
They're not.
State jail enhanced by well, I could,
2 other state jails.
yeah, there's
Times, but you're not doing that.
no.
Right.
Okay.
We could.
All right. And does the defendant waive formal readings of these indictments? Can we proceed in summary?
Yes, Your Honor.
In 310, paragraph 1 alleges that on or about December 11th, 2022 in Jefferson County, Texas, you committed the state jail felony of illegal possession of cocaine, a controlled substance. Do you understand what you're charged with? In 311, this indictment alleges in paragraph 1 and 2 that on or about December 11th, 2022 in Jefferson County, Texas, you committed the state jail felony of evading arrest or detention by intentionally fleeing from a peace officer who was attempting lawfully to arrest or detain you. And you have been convicted of 1 or more prior evading arrests or detention in looks like on June 23rd of 2021, you picked up 2 convictions in the 252nd District Court next door for that. Paragraphs 1 and 2, thus in this 311 indictment constitute a state jail felony as well. Do you understand what you're charged with?
Yes.
If convicted of a state jail felony, in each case, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached where you would be pleading guilty. Sentence, is it 12 months or 1 year?
1 year, yes.
We're gonna just, that's
However you want to do it.
1 year in the state jail. Is that your understanding to run concurrently with each other?
Yes, sir.
If I follow these agreements or the agreement in each of these two cases, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead then in 23 CR 310, the state jail felony of illegal possession of controlled substance, guilty or not guilty?
Yes.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
And in 23 CR 311, charging you with the state jail felony in paragraphs 1 and 2 with evading arrest and detention with a previous conviction of an evading arrest or detention. Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And that second paragraph of the previous evading arrests or detention, are those allegations true and correct as they are alleged? And are you pleading true and correct that those allegations in paragraph 2 of 311 voluntarily, knowingly, and intelligent?
Yes, sir.
I show you what's marked as State's Exhibit 1 in each case. Did you sign those documents?
Yes, sir.
Did you understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir. I did.
State's Exhibit 1 in each case are tendered
No objection.
without objection admitted. Among other things, the state that in each case you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you, or you've read them. You were guilty of the crimes charged and any lesser included offenses. You were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true in each case. So help you God. Is that so?
Yes, sir.
All right, State's Exhibit 1 in each case will be admitted into evidence without objection. Pre-sentence reports waived? in
Yes,
each
Your Honor, we
case?
request that.
Place in paragraphs 1 and 2
Yes, sir.
on this 311.
I should have done that.
All right, if nothing further to add, I'm going to find in each of these cases, sir, you have pleaded guilty voluntarily, knowingly, intelligently to paragraph 1 in 310 and paragraphs 1 and 2 in 311, which constitute state jail felonies in each case. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty in each of these cases. There's sufficient evidence from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I so find and find in each of these cases, you were hereby found guilty beyond a reasonable doubt of these state jail felonies in paragraph 1 of 23 CR 310 and paragraphs 1 and 2 of 311, as you have pleaded true to paragraph 2 of the prior evading arrests voluntarily, knowingly, intelligently, which make thereafter any evading arrest automatically a felony from here on. That's what you face because of the prior convictions. You are hereby found guilty of each of these state jail felonies. I'm following these agreements. You are hereby sentenced to confinement in a state jail for 1 year on each of these cases to run concurrently. Do you understand what has happened today?
Yes, sir.
Anything else? That is all. Thank you.
Aye.
Oh,
Mr. Scholes,
Yes, ma'am.
how are you today?
I'm all right, ma'am. How you doing?
Mr. Scholes, if
But looked like they were just going to set trials for the rest of them. At least that's what they were saying.
So I feel like we never saw you, and now I feel like I'm seeing you a lot. What's going on? I'm concerned.
I mean, I don't know. They just.
I think, do you need to seek some treatment for some maybe drugs or alcohol?
No, ma'am. I ain't nothing like that. They just put a charge on me. Something that
They put this public intoxication because they said that you were.
I didn't even have no alcohol on me, ma'am. They smell like alcohol.
Bear in mind, he said they just dropped a charge on me, something I didn't do. Wait for it.
Or nothing.
But you don't have to have alcohol on you, sir.
Yeah, but
public intoxication is defined a lot of different ways.
I didn't even smell like no alcohol or nothing.
Did you hear what I just said, Mr. Schultz?
Yes, ma'am.
It doesn't have to be alcohol. It's
Okay,
intoxication in any way.
I didn't have nothing.
Okay, you hadn't had any drugs?
No, ma'am.
You want to have a trial?
But no, ma'am. I'm good. I'd rather I plead guilty, ma'am.
Because
I had nothing. I wasn't drunk. Whatever. They made up charges on me. I plead guilty. Okay.
Let's talk about what the definition of intoxication is, right? Just so that you feel a little bit better about it. It says public intoxication is intoxicated either by reason of the introduction of alcohol, a controlled substance, a drug, a combination of substances, or any other substance into defendant's body, that's you, to the degree that you may have been a danger to yourself or others.
Okay.
It's you were scaring people. Looks like maybe you had an argument with some unknown person and
without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack. And
middle of the street with traffic on McMaster's. That's busy. Okay. So you pleading guilty or no contest?
Guilty, ma'am.
Okay. So Mr. Schultz, I am going to find you guilty. I'm actually going to time serve you. Okay.
Charges.
Yes, ma'am.
That's why.
Please get some help if you need it.
Yes, ma'am.
Okay.
Yes, ma'am.
I'm concerned about you, sir.
I will,
Okay.
ma'am.
Okay. Thank you, Mr. Schultz. Good luck.
Thank you, ma'am.
I like Hamilton.
Mr. Calfon?
It's
She's fun.
yeah.
Mr. Calfon, on November 26th of 2022, you were charged with the offense of having an unauthorized buyer's tag on your vehicle. And then on March 19th of 2023, you were charged with the offense of failure to maintain financial responsibility. Second, that's punishable by a fine of $1 to $350 to $1,000. And then on that same day, they said you were driving in a center lane over there on Amarillo Boulevard. That was about 9 o'clock at night on a Sunday. Sir, you can plead not guilty, no contest, or guilty to these cases. What do you want to do?
Guilty.
You plead guilty. I'm going to find you guilty. I'm going to assess fines and court costs in the amount of $242 on the unauthorized buyer's tag, $733 on the no insurance second, and driving in that center lane, $330. I will give you 1 day jail credit on each one of those. Looks like your balance is going to be about $855. I will then release you to appear here at municipal court no later than 2 p.m. on the first business day following your release. Is that your understanding?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Okay, we will see you Tuesday at 2 o'clock. Do not be late.
Okay.
Mr. Edwards. Hi, Mr. Edwards.
How you doing?
I'm good. Hey, you've got 2 different charges. One, walking on the roadway where sidewalk is provided. That's from May 26, 2023, 3:40 in the afternoon. And then you have a pedestrian crossing between the intersection where it's prohibited. Sir, you may plead not guilty, no contest, or guilty. How do you want to handle these?
No contest, ma'am.
Your time served on both of them, sir. Okay,
Thank you,
good luck to you.
Go to the pod.
Yes. They'll
This guy
take
just
care of
can't
you.
find his
Thank
way
you.
out.
Thank you. You gotta get me out. No, you just turned the door knob. Oh, okay. Oh.
Crabtree?
Oh.
Yeah, but he's dangerous about it. He's about to get
Ms.
hurt.
Crabtree, you have public intoxication from yesterday. Do you want to plead not guilty, no contest, or guilty?
Guilty.
I'm sorry?
Yeah, I'd say no contesting.
Okay, I just couldn't hear you. I'm sorry. Okay, that's a $400
She said guilty. Then she moved it to no contest, which doesn't matter. But, for the record, that's what happened.
$84 fine and court cost and will find you guilty of the offense based on your plea of no contest. I will release you to appear here at municipal court no later than 2 p.m. on the first business day following your release. You do receive 2 days jail credit. Your balance is $184. Do you have any questions?
No, ma'am.
Okay.
Like released today?
Yeah, deputy is going to give you a map of directions to our court. Make sure you show up by Tuesday at 2 o'clock. Good luck.
Thank you, ma'am.
Thank you. Justin Davidson.
Yes, ma'am.
Mr. Davidson, on Saturday, you received a citation for public intoxication. You may plead not guilty, no contest, or guilty. What do you choose?
Is not guilty when we fight it in court? Or
That's my favorite. Is not guilty where we fight it in court. Well, your other options are guilty and no contest. So yes. I don't know. It's too fun.
Yes.
yes, that's what I would like to plead, ma'am.
Okay, let me take a look at your history. You have 2 other cases set for trial on July 6th.
Yes, ma'am.
Okay.
Oh man, I gotta get together.
Okay, I'll give you another PR bond. Looks like you actually show up. Thank you.
Yes, ma'am. I just have kids trying to blackmail me and I get mad, ma'am. So
Wow. Okay.
I got an attorney working on the situation.
Okay, well, if you're going to have an attorney for your hearing on July 6th, you better, do you have one hired already?
Yes, ma'am.
Who is it?
Ashley Porter.
Well, I have no clue who Ashley Porter is, but she'll need to file a rep letter if she's going to represent you. So make sure when you get out, first come here 2 o'clock on Tuesday, and then you make sure you get Ms. Porter to file the appropriate paperwork with our court, okay?
Yes,
I
ma'am.
hope this isn't
Thank
Ashley
you.
Porter.
Any objection? All objections.
Ah, you may leave. Ms. Ferris?
Thank you, sir.
Ms. Ferris, you have a citation for possession of drug paraphernalia. Looks like that could be associated with the higher charge. You may plead not guilty, no contest, or guilty.
Guilty.
If you plead guilty, I will find you guilty. I will assess fine and court cost of $531. I'll give you 1 day jail credit. Is that your understanding?
Yes, ma'am.
We'll give you 1 day jail credit. Your balance is $381. Don't forget what I said about the fact that you have the right to file a motion for new trial. So if you get out of jail and you think, maybe I shouldn't have pled guilty to that, you make sure you get here within that 10 days of today's date to file that motion for new trial. Do you have any questions?
No, ma'am.
Okay, you're free to go. The deputy is going to give you a map of directions to our court.
I get to get out today?
On our charge, I don't know what you've done on your state jail felony.
Oh.
Good luck.
And good morning, Lincoln Park. How are you?
All right, I had to do one from Detroit for holiday court. Darn it, I looked yesterday and I don't know what was going on, but people in Detroit were, relatively speaking, behaving themselves.
And is this Detective Brown?
It is.
All right, great. This will be, and ma'am, what is your name, please?
Brittany Bell.
Thank you. This will be case 8223-712-997, State of Michigan versus Courtney Renee Bell. And Detective, your name for the record, please.
Detective Michael Brown.
Do you swear or affirm the testimony you'll provide in this matter will be true? And are you testifying from personal knowledge or from an investigative report? Thank you. And just because your mic is dropping out, if you could keep your voice up a little bit, feel free to proceed with your testimony.
Okay. Officers Kosmolsky and Moor dispatched to the Family Dollar in Lincoln Park, 2027 Kinley Avenue on 6/15/23 for a report of a retail frauds robbery that occurred at 19:04 hours. Upon arrival, Officer Kosmolsky made contact with store manager Michael Niemczyk, who reported one of his employees, Mr. Scott Major, was assaulted when attempted to prevent a suspect, Courtney Bell, from leaving the store with stolen merchandise. Michael provided a description of Courtney as Officer Kosmolsky, who was later found by officers. Officer Kosmolsky spoke with Scott and reported Courtney into the store with a large tote bag. Scott recognized Courtney from prior retail frauds at the store. Scott called us for a man in front of the store. When he got to the front of the door, Scott, when he got to the front, locked the door to prevent Courtney from leaving with stolen merchandise. Courtney punched him, kicked him, and sprayed him with mace. Courtney then fled. Officer Kosmolsky also spoke with store employee Jennifer Meir, who witnessed the incident. Jennifer gave the same account that Scott did. Officer Kosmolsky was able to locate the mace on the floor, which was identified as the same one Courtney used to spray it. Officer Murray located Courtney riding a bicycle northbound 4th Street from the location. Officer Murray's Courtney matched the description provided by Officer Kosmolsky. Officer Murray located bags of merchandise that came from the Family Dollar that were taken back to the store, identified as the stolen merchandise. At that point, Courtney was placed under arrest. Detective Larry Coulter was assigned this case and spoke with worker Diana. She did have access to the video camera and was able to burn a copy for him. Detective Coulter spoke with Scott Major by phone. Scott said he was working when he believed he recognized the defendant Courtney Bell stolen in the past. Courtney was carrying a bag. Courtney walked in the store and then approached Scott to register. Courtney presented one item to pay for it. Scott had observed merchandise from the store inside Courtney's bag. Scott called for coworkers coming to the front door. He then walked to the entrance exit doors to lock the doors to prevent Courtney from leaving the store with the stolen merchandise. Scott was unable to lock the door, but did hold the door as Courtney attempted to leave the store without paying for the merchandise. Scott said that Courtney was trying to push the door open and sprayed him in the face with mace.
Well,
Scott then grabbed the bag Courtney was holding, and the two began to struggle over the bag. During the struggle over the bag, Courtney punched and kicked Scott. Courtney then let go of the bag and fled. They said Courtney dropped the mace canister in the store, which was the mace that was recovered by Officer Kosmolsky. Scott did not seek medical attention. During the interview with Courtney, Detective asked the young man tried to stop her. Courtney said yes. Courtney did not. And then during the interview, Courtney also admitted that she did try to fight the young man who stopped her.
The judge gets into it with the defense attorney over this.
And was there anything about her intent to trade these items with a drug dealer, presumably for drugs or something of that nature?
Yes, during the interview, Courtney says she's been on heroin and fentanyl for the past 5 years. Courtney is dope sick and used the drug, or has not used drugs since the previous morning, and that she was going to sell the drugs, or sell the items for drugs to her dope man.
Okay, I thought it was meth. I wasn't sure, but he says heroin and fentanyl. So the big scheme here is apparently her drug dealer said, or at least there's some market for these items. Because I was thinking, why are you stealing from a Dollar General? I mean, it's like the cheapest place, isn't it? I don't know. I don't shop there. I think it's cheap. It doesn't seem like a good crime thing. But what she's doing is stealing from Dollar General to either give the items or the proceeds to a drug dealer.
Yeah. Thank you. I do find probable cause to sign the warrant and counsel as to the arraignment.
Thank you.
Your Honor, may it please the court, Philip Reagan on behalf of Ms. Bell would waive the formal reading stand mute at this time.
Court will enter a not guilty plea on your client's behalf. As to bond counsel, and obviously there's going to be no contact with the store and no drugs provision, but feel free to be creative on what we can do with Ms. Bell to prevent this from happening again.
Well, Judge, I do understand she does have some priors. We are, obviously in the business of you're in the business of protecting the community, Judge, and also looking at whether or not she's a flight risk. Judge, Miss Bell, this is a non-assaultive situation. Ms. Bell has to, if this is a situation where it is narcotic related, I'm sure she wants to get help to try and kick whatever habit she may have. No contact, obviously, as the court has already stated, would be the provision. Because it's a non-assaultive case, Judge, I'm going to ask.
Counsel, I don't often cut you off, but I would think that kicking the store employee in the groin and spraying him in the face with mace would not qualify as non-assaultive, but go ahead.
Well, Judge,
I like this judge. In fact, I made a great short out of him last night from a prior. He's fun. And I like this attorney. I think they're both good, but the attorney has no argument, so he proceeds with a horrible argument. And the judge, you can tell he respects him. He's like, yeah, we know each other. We do this every day, but you got to stop with this argument. Stop telling me that her kicking an employee and macing him is non-assaultive. I'm not buying it.
His charge is an unarmed robbery. She's not charged with an assault or a FA, GBH, or even a simple assault, Judge. It's simply unarmed robbery and organized crime. And I do understand, we look at the investigator's report for certain things, Judge, but, I like, sometimes to stay within the four corners of the complaint in terms of what the charges are. But I do understand.
And I agree with you, but if we read count one carefully, we notice that the definition of unarmed robbery is to use force or violence against a person present, notably this Scott Major. So I'd have to quarrel with you that this is non-assaultive.
Well, and I understand your position, Your Honor, and mine, is going to be, this is a young lady who, and these are just allegations at this point still, Judge. We're not trying the case today. We're simply, obviously setting bond. She'll have her day in court. There's a process to this. We all know what the process is, and that's a great thing that we have that. But right now, Judge, I know what you have to do. You have to put something in place to protect the community and to make sure she comes back to court. I think, Judge, if the court says absolutely no contact with Family Dollar, she won't go back. I think that one of the conditions, obviously no drugs, and Miss Bell may want to look into going into some type of treatment or getting some type of help. My goal is to see, I want to see her win. I don't want to see her, locked up, but I do want to see her get some help if she does have a drug habit. That's very important. But again, Judge, I'm asking the court to consider a personal bond. I don't know if a tether is necessary in this particular situation, but I do understand the court wishes to protect or maybe know where Miss Bell's whereabouts are. So a tether may be a something that the court may want to include prior to release, Your Honor. But I am asking for personal bond, Judge.
Is she working at all, to your knowledge?
She is not working right now, Your Honor, unfortunately. We have a good phone number for Miss Bell. I'm sorry. But that's about it, Judge. She's not working.
It's a rough argument.
To my knowledge. So I want to be forthright with the court regarding that.
Okay. Thank you, counsel. Here's what we'll do. Miss Bell, while this case is pending, you're to have no contact with any Family Dollar store anywhere. You're not to use any illegal drugs at any time, and you will be on a GPS tether on house arrest. Fine will be posted set at $5,000 personal. Next court date is June 27 for a probable cause conference, July 3rd, preliminary exam, both.
I give the defense attorney credit after going too far with the first argument, and I get why, because he doesn't have another one. He's not a bad attorney. He's a good attorney. Then when the judge asks about employment, and he's just like, I'd like to tell you otherwise, but no, she doesn't have a job. Just house arrest her.
In 25th District Court in Lincoln Park. Anything else for the record?
No, Judge. Thank you very much.
Thank you. Thank you, Lincoln Park. Have a great day.
Well, there you have it. Always fun. Always a challenge to find material on a holiday weekend. But, the good thing was Judge Stevens got going today. That was pure luck. I just grabbed a bit of that. I didn't even watch it. I just poured myself a cup of coffee and let Judge Stevens go. And that turned out to be fun. So thank you all for coming out. I appreciate it. Everybody behave yourselves. Don't get arrested. If you're drinking, Call an Uber. I'll see you soon.